Any adjournment request?
Wait, please, my lord. My lord, item number 4, my lord, I'm appearing for the appellant, my lord. The adjournment slip had been circulated. Obliged, my lord.
Any other request? Daily list for orders item 1.
Lord, in this case, my lord,
I'm appearing for the sole respondent.
hold respondent.
Lord,
I'll serve a copy, my lord.
I look at number 2 day.
This one should put an appearance on behalf of the sole respondent. Services therefore complete. Copy of the writ of appeal be supplied to the counsel for the sole respondent during the course of the day itself. Stop list this matter for the admission when
After 2 weeks.
after 3 weeks.
Obliged.
Item number 2.
My lord, I have received the, my lord, affidavit opposition filed by respondent number 5 in the IA, my lord, whereby it is showing, and when they are trying to say that the as per the instruction of the, my lord, government advocates, whatever he has written his letter, but order has been communicated, my lord. Total interpretation is, my lord.
Sir, Andy, listen. The learned single judges set aside your termination.
Well.
They set aside your appointment. Okay,
My lord.
and if now, as per the interim order, though maybe we have ordered that 7, 8 and 9 may be assigned some other duties, but
Well.
if they have assigned you the other duties, what's the problem in that? Since March you have not joined there?
But I have no problem, my lord.
You have no problem, then first
My lord.
join and then only agitate the matter, otherwise.
My lord,
okay,
only one thing I want, my
then
lord.
if you are not ready to join, okay, then argue
My lord, I am ready to join.
the writ appeal on merits itself, we'll decide it.
My lord,
Because
I ready to join, but my stand is, my lord, as the honorable court has given a specific direction, that is a totally,
We
my
have
lord,
given
wrong
the
interpretation,
direction.
my lord.
We have given the direction.
Yes, my lord.
Now we are giving you a direction that
Yes, my lord.
Join,
If lordship has given the direction, I will join, my lord. No problem. My lord.
where we have given this join the posting where they have given.
But I am ready to accept, my lord. But the,
Beggars can't be choosers, sir.
my lord, I am, my lord, ready to accept, my lord.
That is, you are here
My
before
lord,
to
my lord.
save your appointment, and now you are putting the condition. That,
No, no, my
okay,
lord, not on that, my
as
lord.
per this stay order, I should be posted here and there, and that will not.
No, my lord, only, my lord, whenever lordship was pleased to pass a specific order,
What?
I,
Okay, fine.
that
We
is-
have passed that
that-
order.
but there is a wrong interpretation, that is I am on step.
Okay, fine. We'll,
If lordship has given the direction,
we'll
but
take
I have
care
not.
of that. If a wrong interpretation is there, first go and join, and then
My
only
lord,
come
my
and
lord,
argue.
I'll join, my lord.
When
But as your lordship, my lord,
and your honorarium will start. They'll pay your honorarium from the date of joining and not before that.
but my lord, from the date of my release, in spite of the order, that is on.
Whatever it may be,
But that should be released.
whatever it may be, first join, and honorarium will decide later on whether you are entitled for that or not. Since you have not worked, since January you have not even joined.
My lord, I was attending the same my original place, my lord.
Why?
Because
When they
there is,
already posted you somewhere.
because I have obliged the
First-
honorable court order, my
First,
lord.
your duty was to join and then come before.
I will join, my lord. That I did not join because
Withdraw
of that
this
I am
application.
complying the honorable court order. But that is why I have not joined.
Withdraw this application or otherwise argue the matter on merits. We'll
My
decide.
lord, I am ready to join. No problem, my lord.
Then withdraw this.
Then my
Senate counsel for this IA is preferred on behalf of IA is preferred on behalf of the applicants with a prayer to interfere with the order dated 24th of January 2025, where the Child Development Project Officer Takhu Khana Dakwa Khana Dakwa Khana has directed the petitioners, the applicants to join and perform their duties at the Anganwadi centers mentioned in the order itself. Full stop. yeah, indicated in the orders, order dated 24th of January 2025 itself. Full stop. Learned, the applicant says prayed for staying the operation of the order dated 24th of January 2025, claiming that as a matter of fact, this court, while this court wide order dated 25/11/2024 passed in writ appeal number passed in IA number 3542/2024, filed in IA number
I am alias, my lord. This is I am.
in writ appeal number 327/2024, has directed the respondents to has stayed the effect and operation of the order dated 25/10/2024, whereby the applicants were released from duties of the Anganwadi worker with immediate effect, and has further directed that since the respondent number 8, 7, 8, and 9 in the appeal, in the writ appeal, have been appointed in place of the applicants, their appointments may also not be disturbed, and the CDPO may assign them work at different Anganwadi center nearby to the Anganwadi center in question. It is submitted that though this court has granted has issued specific direction to adjust respondent number 7, 8, and 9 of the writ appeal at different Anganwadi center near the nearby to the Anganwadi center in question, but the respondent, instead of assigning work to the 7, 8, 9 at different Anganwadi center, has assigned duty to the applicant number 1, 2, 3 different Anganwadi center. Full stop. It is noticed that though the order dated 25/1/2024, though the order was passed on, the order in field was passed on 24th of January 2024, but till date, the applicants have not joined at the place where they have been asked to discharge their duties temporarily pursuant to the order, interim order passed by this court. Full stop. After attempting to argue the matter for quite some time, learned counsel on instructions has submitted that he wants to withdraw this IA. However, this IA, full stop, taking into consideration the above submission made by the counsel for the applicant, this IA is dismissed as withdrawn. The applicants are directed to join at the place where they have been assigned to discharge their duties by the order dated 24th of January 2025. The respondents are directed to pay the honorarium to the applicants from the date of joining at the place indicated in the order dated 25th of January 2024, 25.
Masam.
Application is disposed of.
Mas.
Item number 3.
Notice, yes, to go.
Notice returnable.
Item 5.
Against Judge order High Court 123 passing OA 2020.
Similar order is there.
Malo, is the order.
Number 2.
Same order.
I love it.
Thank you. Thank you.
Okay, so ma'am.
Item 6,
ये जूनियर नोट्स First of all, for the time being.
supplementary list item 11 for orders.
My lord, the I is for condemnation of delay, my lord. There is a delay of 6 days only, my lord, in the appeal. Against the order of the income tax appellate authority, my lord.
I'm appealing for the income tax department.
क्या कहना है? Delay of 6 days. You are appealing for all the respondents.
Yes, my lord. All.
No, Lord, if only for the income tax department.
Who is appearing for the Union of India? Union of India is a formal party.
Yes,
Yes, sir.
Income tax, office of the income tax, VAT number exemption, ये Union of India represented Ministry of Finance, income tax, office of the income tax, VAT number 2, 3 exemption, Guwahati. They represented through that. I don't know whether it's
I can,
ठीक है, the matter comes upon for consideration of the IA number so and so with a prayer to condone the delay of 6 days in filing connected income tax appeal. It's called. Mr. Kyle is appearing on behalf of all the respondents. That is the income tax department, that is the officials of the income tax department.
No.
Service is therefore complete. Mr. Kyle has not seriously opposed the condonation application, hence the IA is allowed the delay of 6 days in filing the connected income tax appeal is condoned. Registry is directed to the register the connected income tax appeal and listed before this court after 3 weeks. Showing name of Mr. Kyle as counsel for the respondent.
much obliged.
Daily list for hearing item 7 to 9.
May it please me. My lord, I am intentionally standing on this side, my lord. There are,
Intentionally, what is your intention? How come we know?
but I may explain that, my lord. My lord, there are 3 appeals before my
Yes,
lord. My lord, in the
two by
first one, I am the appellant.
Two
but-
by the department and or
Yes,
Coal India
correct.
Limited and run by
Yes, my lord.
matter regarding the interest.
Lordship pleases, my lord. My appeal is on interest, my lord. The main appeal is, my lord, on behalf of the department. Therefore, my lord, I said I stand on this side. Subject to my lord's.
What is in there, your appeal?
My lord, my appeal is founded on the premise that some money which was due to me was withheld by the department.
Yeah,
It remained withheld for quite some time. Eventually, the matter was decided in my favor. My lord, of course, my lord, the direction at the penultimate paragraph of the judgment is that they will make settlement and pay us. So, my lord, my entitlement to interest,
the learned single judge has made it clear in the later order that there was no intention of the court to grant interest. What remains? That is,
my lord, interest should be natural accretion to my capital, my lord. It was my money.
but in a given case, if the court doesn't find it necessary, court can very well. say,
My lord, I leave it upon your lordship, my lord.
No, why to interfere with the discretion of the learned single judge which he has exercised and found that the interest is not required to be paid, then what's wrong in? Every order is not supposed to be interfered by.
My lord, I was in the first appeal, therefore, my lord, I thought I could persuade. My lord, had it been, my lord, a writ jurisdiction.
Ultimately, sir, either some law that it is mandated that
My-
you have to pay the interest.
Yeah,
If
quite-
law is not there, then certainly the discretion exercised by the learned single judge is not supposed to interfere in each and every case.
My
That
lord,
is the position of the laws.
My lord, it could only be considered, my lord. Of course, discretion was there. Discretion exercised in one way or the other way, my lord. In administrative law principles, my lord, normally appellate.
And recently, in various Supreme Court judgments, they have said if the learned single judge exercises jurisdiction in each and every case until and unless the finding is perverse or something which is against the law.
My lord, could I say something else, my lord?
Yeah.
I confine it to this, my lord, that, my lord, that interest aspect should be left open. They haven't paid to us as yet. The judgment has not been complied with. So, my lord, my lord, opportunity to even file a suit.
It's an attempt, to be very frank, it's your attempt to defend that appeals more filed by the Coal India Limited. So to balance the equities, okay, don't grant us relief, don't grant
But
relief
since-
to them also. This
Milord,
is what
Milord,
the
may I appreciate, Milord,
attempt, we understand.
2030.
Because in 18, they have preferred an appeals in 18 and you have preferred this appeal in
My lord,
2022.
we preferred
after
a
2
review.
years.
We preferred a review, my lord. So, my lord, my lord, the prospects, my lord, I'm on
That
something else, my
review
lord.
was
Could I, my
also
lord?
decided way back
Being-
in the
being
year
very sincere and-
2019, I think.
My lord, being very sincere and serious, my lord, may I make a submission, my lord, as an officer of the.
Maybe we
My lord, my
appreciate your
prospect.
attempt to preempt that
My lord, may please.
We'll see.
My lord, may please view it from another angle, my lord, which I am trying to project subject to kind permission of the bench. My lord, my prospects of claiming interest from the department by way of a regular civil suit later, my lord, when they eventually settle my money, they haven't as yet. That also gets, my lord, shut by the observation of the review court, my lord, to the extent that it should be implied that the honorable single judge has refused interest. There was no express refusal.
But implied.
Of course, my lord, I took the chance and
Yes, the court has given this opinion that it is implied that the court was not inclined to grant, but the court has not stopped you from.
my lord, that may be
appealing.
clarified, my lord.
That is there, sir.
That may be clarified.
You just read the order. Read the order.
Yeah. My lord, the order of the honorable single judge,
The later order.
the later order, my lord, review order.
Yes. When the writ court has directed settle the outstanding dues of the petitioner after making necessary adjustment without mentioning about interest, it is implicit that the writ court had not acceded to the prayer of the petitioner for a direction to pay interest. That's a simple observation.
My lord, that could only be clarified by this appellate bench, my lord, that this doesn't forfeit. This doesn't forfeit my right to claim interest, my lord, in appropriate jurisdiction.
Isn't it?
Coal India Limited, your appeal is there.
Eight and nine, 8 and 9.
That's
8 and 9.
Yours is 8 and
consider their appeal.
Yes, yes.
9 to what level. 9 to what level. I don't know. So please do take up item number 9 first.
Item number 9.
9, that's okay.
Give us the item number 9 first.
338. 338. Just went to the, please do this. Start with this. What determined. Immediately connected. Probably educated. No, yeah. That's settled the balance. Hmm? Okay, may I submit the list of dates?
Just a minute. Please, you take your seat.
Yeah.
The copy of the NIT is available on record,
Yes.
which is that?
From page 29.
The NIT starts
That's page
at
29.
page
In item
28.
number 9, in item number
Yes,
9,
Mr. Page 28 of volume 1.
Page
28,
29.
volume,
The page 28, it starts annexure P by 1. The relevant,
where is that clause 6,
below page 58.
58?
Yes, running page 50.
Yes, Sir,
Protected. So you giving us one list of dates. That too. Make you load it. It is load. Here you load it. We had on 28/3/2008 loaded tenders for 4 separate patches. We call it patches. We demarcate particular areas for mining. And 29. Here it was 4 patches for extraction of hard shale, which is coal, and carbonaceous shale, which is earth. And that you also see it in the tender
I
notice.
think the dates are not in dispute.
These are not in this.
Dates are not in dispute. Now, the only question is, that the learned single judge has come to the conclusion that the invocation of clause 6.2 and 6.3 is not justified in the facts and circumstances of the case. Because the 2 contracts were there. In one contract, you have terminated the contract without extension of time. First contract was terminated on the last day of contract. Expiry of the contract came to an end.
Came to an end.
And in the second case, you have extended the time up to 30th of June 2015. But prior to that, on 26/6/2016, contract was terminated. And up to that time, 97% of some excavation was completed by him. So, in some substance, as per our understanding, the learned single judge has come to the conclusion that without quantifying the liquidated damages, you can't impose that this liquidated damages or the forfeiture. You can't forfeit the security and the bank guarantee for that purpose. First, you adjudicate and then only you can claim. This is what the sum and substance, as per our understanding. If some other meaning is there, you just,
Lordship, this is damage clause 6.2 clearly states what is the quantum of compensation that I can recover.
while in support of his reasoning, the learned single judge has come to the conclusion that after the expiry of the period of contract and termination of the contract, he was not allowed, he was not supposed to carry the work for this removal of
Coal,
whatever
yes.
the coal or whatever the
Extraction of
materials.
coal.
That was in your possession. So how much he has extracted and how much remain in the earth, which was expected to be removed from him, that is no adjudication is there. So it is kept open for you.
Lordship, what happened was you would have gone for a suit,
For
but for a suit,
suit for why suit?
for recovery of the amount.
Recovery. First you have to calculate the amount, na sir.
That we've got the calculations.
Yeah.
We've got the calculations.
You got
But
the calculation, but
Writ court
yeah.
will not go into defect.
that calculation you have covered. You have already done. But the learned single judge here in para number specific, if you come to this para number 38, suppose,
30.
of the impugned order.
Yes.
As for invocation of section 74 and held by Supreme Court so and so, damage or loss caused to one of the party to the controversy is sine qua non for applicability of the sixth section. Insofar the present case is concerned, all that is happened is that certain quality of coal remain embedded in the earth which could not be extracted by the petitioner, or certain quality of coal could not be transported to the siting of the coal. The quantity of coal has remained in the custody of the respondent. Therefore, it would not be correct to say that for the inability of the petitioner for whatever reason to complete the extraction of the loss of or the transportation within the contractual period or extended contractual loss or damage was suffered by the respondent, and the same in any case was not quantified. Here they have specifically said what amount of coal was remained there, what amount of coal they have extracted. There is no, I mean to say, calculation is there, which go into the mind of the learned single judge. He said, first determine and then you can do that. This is what we understand.
That is what this learned single judge has said. But actually, whether this court could have gone into that aspect of the matter.
Why not? If the facts are very clear, then certainly
It's a pure contractual matter. Disputed questions are there.
ultimately the court has granted you liberty to get the liquidation damages collected from him, but at least some calculation must be there.
The
So
calculation
whatever the calculation you have done, the learned single judge has disapproved that.
Page 1, page 8, volume 2.
Lordship, please visit page 14
Volume 2.
of volume 2.
Volume 2, class number 12. Page number 12 of the start.
We have quantified the loss we've suffered from, in our affidavit, we detailed it.
Sir,
At page 12
well,
Volume 2.
of volume 2.
Within repetition. Volume 2. Like it was not a how many people said it is the damage?
Yes,
You will see, the first at page 12, did up west patch.
Yeah.
You got it?
Yeah.
We have the formula, on the basis of the formula, we have calculated and we have quantified the loss suffered. In there,
But we did not bring in, it's a following. I think did not bring in the record.
and the entire details of calculations are there with us. We did not bring it on record before this honorable court. It is not necessary. Court could not have gone into it.
You know, the thoughtful in production. Then I
sir, up to what extent you can recover this liquidated damage?
10%.
So directly, you have imposed 10%.
10%.
Without even adjudication, how much
No,
will remain
On the basis of
unexpected?
the calculation, our loss was much higher. It was near about 700 lakhs.
we imposed only 1200. I mean, walk out month-wise, every talk to the walk out. You have to be thoughtful in production. You have to.
Petitioner was fully aware of its target and what was the extraction done. And it was 61% average.
Yes, sir.
But I would suggest, in the facts of the case, your lordship will not go into the merits of the case. The Red Court also did not go into it. It relied only on section 73 and 74. But fact is, we did incur loss. Our loss was near about 700 lakhs. But we have imposed penalty of about 1200.
By the transfer then.
And if you need to establish it, I have no problem. You could have gone us in the suit and brought out all the details. But since the petitioner came before this honorable court earlier, and this honorable court directed that we don't disturb them. Hence,
The problem is the petitioner came before this court and therefore you were forced to go into the litigation. And here now the court has passed the order, whatever the order, then to defend that order, he has filed another appeal. That is what is going on.
no, that for interest. Because
Interest there is-
and that on
No,
view it
interest,
is different.
still the learned single judge has kept it open to quantify and then only ask for this liquidated damages. There is a question of interest. The court has not granted any order to make the payment to them. So and so payment. Still it is open. So where is the
Lordship-
question of interest?
Very true, Your Lordship,
We understand. but
it is open, they have not come forward to provide details. Ever since the judgment, we've been waiting. We shall let them come, we'll negotiate and finalize.
Both of you, some proceedings are going on.
No, no.
Not really.
It said it now that the process is not complete till date.
No, I was saying, my lord, the payments have not been released pursuant, pursuant.
They have to quantify the damage and then only they will
Not
release the
quantify.
payment after adjusting. whatever
With
the-
respect, my lord, there is no liberty given to them to quantify the damages.
See, that
No,
is
no,
there.
that is there. That is very much
Sir,
there.
That is there, sir.
please.
That is there. If you come to this last para. Of course, the respondent would be entitled to make necessary deduction
In the bills, which means, my lord,
from the bills submitted by the petitioner for quantum of coal covered by the contract and which has been remained unextracted and untransported in a siding. That is the only.
that means, my lord, with respect to royalty, etc., taxes, etc., which are to be deducted, my lord, in the bills which I submit, those bills, my lord, are subject to certain deductions. But so far as this damages is concerned, my lord, subject to my lord's approval, but with regard to damages, there is a definite finding that no loss has occasioned unto them. And therefore, they cannot.
No.
Then alternatively,
Sir, if
alternatively,
you mean to say that the doors for them is closed,
yes, my lord,
not at all. The court has clearly said in para number 38. Therefore, it would not be correct to say that the inability for whatever reason, so and so, extracted or transportation within the contractor were or external contractor has lost or damage was suffered by the respondent, the same in any case was not
my
quantified.
lord, that second part, my lord. The first part is concerned, my lord. My lord, may please be with me. My lord.
Quantify, certainly they can quantify and then
Look, that
they can
quantif-
claim the liquidated
Look, that's
damages,
one of-
whatever the rate
My
applicable.
lord, that's the second ground on which,
They can't be stopped from that.
my lord, that's the second ground on which the honorable court has been pleased to non-suit them. But the primary ground is that reliance was placed upon the interpretation placed by the honorable Supreme Court on section 74, which runs slightly contrary to my interest, my lord, but the interpretation goes in my favor. My lord, they said that occasioning of loss is a sine qua non for applicability of section 74. Although, my lord, in express language, section 74 says whether or not actual loss has been caused. My lord, that was subject matter of interpretation by the Supreme Court in Mola Bucks.
Yes.
Then, my lord, it followed, my lord, and ultimately, my lord, in paragraph 37, reliance has been placed upon the judgment of the honorable Supreme Court in Kailashnath Associates. My lord, may I just invite your lordship's kind attention to para 37 for a moment.
Read.
And that was our definite case, my lord. That is what has been accepted.
Read.
My lord, I'm reading from the quoted portion. On a conspectus of the above authorities, the law on compensation for breach of contract under section 74 can be stated to be as follows. Whereas sum is named in a contract as a liquidated amount payable by way of damages, the party complaining of a breach can receive as reasonable compensation. I'll just pause here for a moment. Bro. This is, my lord, the language borrowed from section 74. Such liquidated amount only if it is genuine pre-estimate of damages fixed by both parties. That's the condition and found to be such by the court. Yes, my lord. Yes, my lord. 43.1, my lord.
Yes, yes. Para number 37,
Yes, my lord. I was reading 43.1, my lord.
read, again read.
My lord, I'll start from 37 minutes. Supreme Court in Kailashnath Associates versus so-and-so surveyed the entire legal position pertaining to the specific provisions of section 73 and 74 of the Contract Act and summed up the law of compensation for breach of contract under section 74 as under. On a conspectus of the above authorities, the law on compensation for breach of contract under section 74 can be stated to be as follows. Where a sum is named in a contract as a liquidated amount payable by way of damages, the party complaining of a breach can receive as reasonable compensation such liquidated amount only if it is genuine pre-estimate of damages fixed by both parties and found to be such by the court. In other cases, where a sum is named in a contract as a liquidated amount payable by way of damages, only reasonable compensation can be awarded, not exceeding the amount so stated. Similarly, in cases where the amount fixed is in the nature of penalty, only reasonable compensation can be awarded, not exceeding the penalty so stated. In both cases, the liquidated amount or penalty is the upper limit beyond which the court cannot grant reasonable compensation. 43.2, reasonable compensation will be fixed on well-known principles that are applicable to the law of contract, which are to be found inter alia in section 73 of the Contract Act. 43.3, since section 74 awards reasonable compensation for damage or loss caused by the breach of contract, damage or loss caused is a sine qua non for the applicability of the section.
Fine.
The section applies whether a person, I'm not on that, my lord, 43.6, my lord. So, my lord, 43.3 and 43.6 is, my lord, what clinches. The expression whether or not actual loss, actual damage or loss is proved to have been caused thereby, my lord, in section 74. Means that where it is possible to prove actual damage or loss, such proof is not dispensed with. It is only in cases where damage or loss is difficult or impossible to prove that the liquidated amount named in the contract is a genuine estimate of damage or loss can be awarded. So, my lord, they were required to say at least that there was loss. Even in appeal, my lord, not a word by them that there was actual loss. My lord, what happened, my lord? It seems that they labored under the impression that by virtue of language of section 74, they are not required to go into the question of loss. And just because there is a breach, they are entitled to impose liquidated damages
Now,
to the extent of 10%.
you're right. You're
Now,
right.
my lord, then the honorable court says,
Now
my
they
lord,
have to first of all come with the case that this much of loss they have suffered.
exactly, my lord, that's one.
So that's why
My
only
lord,
what they have now it is.
my lord, just
open
bear
for
with
them.
me. Just,
They can adjudicate it that this much of loss and then only they can.
my lord,
claim
just bear with me, my lord.
damages.
The court did not stop there, my lord. The
Yeah.
court, before holding that they have not discharged their responsibility of even as making assessment of loss,
Yeah.
court has before that said that there was no actual loss caused to you.
Where is that finding?
My lord, please, my lord.
I read.
Please, my lord. They say, my lord, what happens is the nature of the contract is this, my lord. The nature of the contract is this, that I'll do some work for them. I'll receive price for that. If I don't do the work and I receive price, they're at loss. If I don't do the work and I don't receive price,
If they have assigned you the work
yes,
with the condition that you have to do this much of work.
my lord,
within
suppose
this
I
time.
don't do,
This
my lord,
is what
suppose I don't do, my lord. They may suffer loss, they may not suffer loss. It is for the,
No.
one has to make up.
If you don't do, then they'll suffer loss.
My lord, what
Which is the
happens?
question of this.
My lord, my lord, that's what my lord Molla Bugs gives an illustration.
They could have engaged any other person for that.
My lord, that's the illustration, my lord, in Molla Bugs. If your lordship sees Molla Bugs, my lord, for a moment. My lord, their property was supposed to be extracted and transported. I have not done that. My lord, the loss could be had there is a risk purchase clause also. Had they employed somebody else, when I defaulted, they employ somebody else, and that party carries out the work at a higher price. Then that difference is the loss.
Even of the same price, then also the time, where is the time? Suppose they planned it to excavate within a period of 2 years, and within 2 years the contract was continued. You are not doing that.
Yes.
Then another 2 years will consume in that. So that would that is not a loss.
So, my lord, is for them to say that there was loss. My lord, they did not say before the court. Even in appeal, my lord, they don't say. My lord, I have with sense of responsibility, I'm saying, my lord, in this whole appeal, my lord, they have not said a word that they suffered any loss.
Say or say that they say or not to say, but it is understandable, sir. It is a common sense.
No, my lord,
How you can say that even though if I don't do the work within the stipulated time, then also they will not suffer any loss.
my lord, may please see, my lord, the further finding, my lord, in paragraph 38. My lord, may just read paragraph 38 with me, my lord. My lord, may please allow me to, my lord, place para 38 once more, my lord. My lord, read it with me, my lord, kindly, my lord.
Very hard
For a
to
minute.
digest your argument.
For a minute.
Even though if you don't do the work, they will not suffer any loss for that.
My lord, Molla Bugs, my lord, may just.
Allah works.
My lord, but let me just place this, my lord, for a moment, my lord. The factual aspect, my lord, let me be clear. As for invocation of section 74,
Yeah.
as held by Supreme Court in Kalashnar, damage or loss caused to one of the parties to the contract is a sine qua non for applicability of this section. It is in that context, my lord, that they are saying this. In so far, the present case is concerned, all that happened is that certain quantity of coal has remained embedded in earth, which could not be extricated by the petitioner, or certain quantity of coal could not be transported to the siding from the colliery. This quantity of coal has remained in the custody of respondents. Therefore, it would not be correct to say, please, my lord, bear with me, my lord. It would not be correct to say that for the inability of the petitioner for whatsoever reason to complete the extraction or transportation within the contractual period or the extended period, loss or damage was suffered by the respondents. It would not be correct to say that loss was suffered by the respondents. That's the definite finding. And then second finding is, my lord, in any case,
You are, okay, okay, that's why only they have filed the appeal.
And even in appeal,
And
my lord,
we
they don't.
find that this finding of the learned single is not sustainable.
My lord,
not at all.
my lord, I bow down, my lord.
You can't say, okay, they will not suffer any loss. This finding is not sustainable. Then they are justified in this filing this appeal.
My lord, even in
Then
appeal,
are
they
very
don't say a
much
word.
justified.
Therefore, my lord, at the risk of repetition.
And they are very much justified in. If you are saying that the learned single judges come to the conclusion that there is no loss at all caused, that is absolute. Then it can't be sustained. You are upping on that. Then they are right in
My lord,
filing
the
the-
finding is twofold, my lord.
We are questioning them. Why you have filed the appeal in this matter when this is kept open, and if this finding is there, then certainly they are right in filing the. Absolute.
My lord,
This order can't be sustained. You can't presuppose that there can't be any loss to them. When they have granted you a contract.
in
to
fact, your lordship will
excavate
find,
a certain such material in within so and so time. And if you fail to do that, then also it will be presumed that they have not suffered any loss.
my lord,
Sir, if
I
a
don't,
person, suppose
my lord, I
if
don't
a
want your
person,
lordships to
if
presume
a
that. my lord.
person is granted a lease for excavation of the coal for a period of 5 years. He employs a person for 5 years. Okay, you excavate the coal for us. And within 5 years, if that person fails to excavate the coal, what they will do with this mining lease? What they will do with the mining lease? Oh,
My lord, in a
they
given,
can-
in a given situation, my lord, yes, they have to make out that case. And my lord,
That's
therefore, my
what-
lord, I had relied upon, and the honorable single judge has quoted that judgment also, where he said that they can't be arbiter in their own case.
That's what we
They
said.
have,
We
they
are
had to file a suit, my lord, and get an adjudication done,
that's
that this
what
was their loss.
So we'll keep it open. That for the purpose of this recovery of the liquidated damages, they have to quantify what damages or what loss has been caused to them, and then only they can.
My lord,
measure
that
their-
quantification, my lord, that they cannot do it, my lord, that has to be done by an independent arbiter, my lord.
Who are the?
They have to go to the court.
Who are the?
They have to file a suit, my lord,
They'll
for that.
approach him, and then they'll get the damages quantified, and then only they can ask to give the damages.
No, my lord, there is one more thing.
Yeah.
There's one more thing.
This finding, if you are relying on this finding, therefore it would not
We
be
need to
correct to say
complete-
that for the inability or for whatsoever reason to complete the extraction or the transport within the quantity extended quantity period, loss or damage was suffered by the respondent. The same in any case was not quantified.
My lord, to buttress my submissions, my lord. My lord, to buttress my submissions, my lord, to buttress my submissions, my lord. My lord, this judgment will come later, my lord. My lord, may just have a look at the clause first, my lord, of the contract which is involved in this case, so that I can invite your lordship's kind attention to the relevance of this judgment which I am placing. My lord, the clause of the contract, my lord, which your lordship was pleased to see. My lord, will you please see it 6.3.
Yes, sir.
6.3 my lord, bottom expressly talks about risk and cost.
6.3.
Yes, my lord, clause 6.3.
Read.
In the event of such termination of contract as described in clause, the company shall be entitled to recover LD up to 10% of the contract value and forfeit the security deposit besides getting the work completed by other means at the risk and cost of the contractor. But I am saying that it was within the contemplation of the parties that risk cost per provision is also there. Even otherwise, my lord, their loss could be now, my lord, please take a case which was in Maula Bucks, which Kailashnath has relied upon. My lord, Maula Bucks was a case where a contractor was given contract to supply poultry and vegetables to military. Due to World War, my lord, he could not, my lord, the contract could not be performed. And my lord, the government levied penalty or liquidated damages. My lord, all are one and the same, my lord, in view of the language of section 74 as interpreted. Court says that LD or penalty, you can only recover reasonable compensation. And reasonable means it has to be commensurate to the actual loss costing, regardless of the language, which says no actual loss is required. So, my lord, in Molla Bucks, the court was faced with a situation where somebody was, the government had already forfeited some bank guarantee, etc., security. And the argument was that loss has been caused. The other side argued no loss has been established. From that perspective, my lord, the Honorable Court in this Molla Bucks judgment, my lord, kindly take the observation, my lord. Paragraph 6, your lordship, kindly take first. My lord, the observations come, my lord, incidentally, what happens, my lord, in paragraph 6, the lordships are taking note of the argument, but after 6 lines, my lord, the observations of the court is come.
You
So,
just
my lord, I am from that, my lord.
point out from which line.
It is true, my lord. My lord, in paragraph 6, 1, 2,
It
3,
is
4, 5,
true,
6,
yeah.
7, 8, it is true. 8
It's
lines.
true.
It is true that in every case of breach of contract, the person aggrieved by the breach is not required to prove actual loss or damage suffered by him before he can claim a decree, and the court is competent to award reasonable compensation in case of breach, even if no actual damage is proved to have been suffered in consequence of the breach of contract. But the expression whether or not actual damage or loss is proved to have been caused thereby is intended to cover different classes of contracts which come before the court. In case of breach of some contracts, it may be impossible for the court to assess compensation arising from breach, while in other cases, compensation can be calculated in accordance with established rules. Where this court is unable to assess the sum named by the parties, if it be regarded as a genuine pre-estimate, may be taken into consideration as the measure of reasonable compensation, but not if the sum named is in the nature of penalty. Where loss in terms of money can be determined, the party claiming compensation must prove the loss suffered by him. Then comes, my lord, the germane paragraph. In the present case, it was possible for the government of India to lead evidence to prove the rates at which potatoes, poultry, eggs, and fish were purchased by them when the plaintiff failed to deliver regularly and fully the quantity stipulated. They could have proved the rates at which they had to be purchased and also the other incidental charges, but no such attempt was made. All said and done, the sum and substance is that if it is possible, if they take work from somebody else and higher charges are borne, that is one measure of establishing loss. Otherwise, my lord, it has actually been to be left to them to at least claim that there was loss. My lord, we are pitted against a party who doesn't say before the court in either of the two stages that there was any loss. They actually labored under the impression that by virtue of section 74, they are not required to go into the question of loss or no loss. And my lord, that will be more appropriately demonstrated if your lordship sees the second
That
case.
we don't agree. If they are under this impression, without actual loss, they can claim liquidated damages, certainly not. They have to prove the loss. That this much of loss they have caused, they have suffered on account of your action or non-action or inaction or whatever it. They have to prove it.
Now, my lord, what happened?
But you can't say, even though if you have not completed the work assigned to you, there is no loss at all.
No, my lord, that's my lord putting burden upon me, my lord. They have to say, my lord, at least that there was loss upon them. My lord, they haven't said so, my lord. Rather, they have filed a counter affidavit. They cannot improve upon it now. They filed a counter affidavit saying that our loss is the calculation in terms of this 10%.
Maybe
My lord,
wrong.
it's my
It is
lord,
wrong.
putting the horse before the cart.
It is wrong.
Yes,
But-
that's what. my lord.
But they have to, we can't restrain them to claim liquidated damages while saying that there is no loss at all. So these finding, how can this finding can be recorded, sir? Admittedly, you are also admitting that I failed to discharge my whatever the contract given to me.
Yes, my lord. I have certain justification which cannot be adjudicated here.
Taken into consideration. And you can very well say, okay, yes, delay was caused, but I have,
My lord, but in read court, my lord,
there are valid justification for that.
to be fair, my lord, in read court, my lord, we did not raise all that. My lord, we said so, that there are justification. We pleaded that, but we said we are not inviting adjudication on them because we cannot.
That is for them
We cannot.
to take into consideration that justification. Because one of the learned single judge is also allowed your writ petition by taking into consideration that whatever explanation you have given, they have not taken into consideration.
Yes,
that
Lord, in the second case.
also.
In the second case, my lord.
In the
Yes.
second case,
Yes.
and then they directly come to this. So the sum and substance of this judgment is that, yes, you can recover, but first quantify the loss and then only you can claim for this.
And not
liquidated
and
damages.
one more thing, my lord, one additional thing, sir, with permission. And JG Engineers judgment, which has been cited in this judgment, in Honorable Supreme Court judgment, JG Engineers nikal lo. My lord, may just have a look at paragraph. My lord, para 35. My lord, para 35. My lord. In view of this, my lord, my argument was also, as has been recorded in paragraph 35.
डिमांड को never. ये तो visit the chat पर ये देखेंगे. It's based on effective volume. The part of that. Consolidated. Without collateral. Well, carry a delegate from the other. Without collateral. That was not how. Because it's the material is the material recovery with the tension amount of money. Based on
Yes,
The JG engineers, in which reliance was placed by us, as has been recorded in paragraph 35 of the judgment. If at all, my lord, if at all, it is still open for them to uh, allege loss and make quantification.
that is what we are.
My lord, that has to be done by a court. My lord. It cannot be done by them unilaterally.
Whatever the authority is, they're supposed to do, get it done by the court, they'll do by it. If they can do it on your, themselves, they can do it.
Yes, my lord. Because that was also our case, my lord, before the honorable single judge, that it is not within their jurisdiction to do it unilaterally. They can't be arbiter in their own cause.
That quantum the damages as per the applicable law or in accordance with law only.
Well, what they have done is, my lord, they have themselves assessed
If they do the same thing, here the learned single judges, what the purport of this order is, without quantifying the loss, you have directly claimed the damages. So learned single judges said that, of course, you quantify the loss and then only claim the damages. This is what the learned single judges said. Now here, what you have referred to it, this part of the judgment or these observation of the learned single judge, we find that these observations are unwarranted, in fact, and can't be accepted. That there is a situation where no loss is caused.
in a given case, it
Here
may
in
be a
Molla Bakhsh
situation.
case also, the court has interfered because they have failed to
It would
produce
have,
any evidence regarding that. But the operative portion, the plaintiff was guilty of breach of contract. Considerable inconvenience was caused to the military authorities because the failure on the part of the plaintiff to supply food stock contracted to be supplied. Even though there is no evidence that the rate at which the goods were purchased, we are of the view, being regard to the circumstance of the case, the fairest order that each party bear in own cost throughout. They have come to this
That's
conclusion.
about-
Lost to why, but they have failed to prove that. This is what, so you can't say that there is no loss at all. Suppose, sir, if you engage a contractor for construction of your house, and the period for construction of house is 2 years, and within 2 years he failed to complete the construction, and tomorrow he'll come and say, okay, what loss if I have not constructed the house, don't pay me, but what loss you have caused? You have rented accommodation, you
That is the
pay
loss.
the rent for 2 years
is the loss.
more, then there is no loss for that.
my lord, that is the loss, my lord. But if I was not in a rented accommodation, I was having another house which I was occupying,
Then
and I am put to
also-
inconvenience.
then also you have
If I have only suffered inconvenience,
you
my
have
lord.
another house which is a very small house, you face many
my lord,
inconveniences, your children are also
So, my lord, I
facing many
face inconvenience.
Then certainly you can claim the damages. There are many things, many factors. You can say that this new place where I'm supposed to construct my house is near to the school of my children, so I have to pay less for this expense. Many things are there. There are
My lord, in
so
fact-
many factors that you can't imagine.
My lord, I am not joining issues, my lord. In fact, my lord, what
Loss
happens?
can be caused by many ways.
No, my lord, there are many other loopholes, my lord, in their assessment. I can show right away from the
That's why-
contract. That was my point also,
Sir,
which has not been
assessment,
taken
we are
note of.
We are not saying for a moment that whatever they have assessed is absolutely correct. And that
No,
what the learned
for
single
example,
judge has also said.
For example, my lord, just to satisfy my lord's
So where is
judicial
the question of
concerns.
satisfaction? We are saying, yes, their assessment is wrong and therefore the learned single judge has rightly interfered with it. But you can't say that no loss and therefore they can't claim damages. They can very well claim the damages, first quantify them, and then only they can claim the
Lord,
damages. This is what
Lord,
the
fortunately or unfortunately, they have put in place a calculation clause. That LD clause is kind of a calculation formula. 10% of so and so. My lord, if your lordship minutely sees the language of that clause, my lord, it will not fit into our case. It will not fit into our case because of the fact that the language says per week of delay. Now, my lord, if they don't extend the contract, where's the question of delay in terms of week? Putting a question to myself, my lord. The delay has to be calculated first in terms of number of weeks of delay. My lord, please bear with me, my lord. This was the
We are hearing you, sir.
yes, my lord. This was a specific contention raised before the Honorable Reed Court also. Which the Honorable Reed Court somehow, my lord, did not go into. But my lord, the records are, your lordship may see, that was the primary contention. That this clause, the formula laid down in this clause, the factors of that formula are not attracted, not satisfied in this case. Because in this case, and my lord, there is a judgment, my lord, Chunilal Mehta. It says, my lord, if there is a liquidated damages clause, then they are not entitled to also claim unliquidated damages. So, for prospects of claiming unliquidated damages by use of no formula at all, by discretion of the court, is ruled out. They are left to only claim liquidated damages. And if they claim liquidated damages, my lord, they have to thank themselves for the language of the clause, which is not attracted, which is not satisfied in the facts of this case. My lord, may just see, my lord, 6.21. 6.2. If the contractor fails to maintain the required progress in terms of the agreed time and progress chart, or to complete the work and clear the site on or before the contract or extended date,
Yes.
he shall, without prejudice to any other right or remedy available under the law to the company on account of such breach, pay as compensation liquidated damages at 0.5% of the contract price per week of delay. So, my lord, there has to be an assessment first as to what is the number of weeks of delay. Up to the date of contract, my lord, one cannot say there is a delay. Delay can be assessed only when there is an extension granted and I don't finish. My lord, of course, this argument I could have made had they filed a suit, had they been fair to go before a court instead of acting by themselves unilaterally and enforcing upon me this contrivance. Then, my lord, I could have taken this argument in defense. My lord, I am deprived because they don't give us an opportunity to go before an arbiter, a court, and straight away, my lord, what they do is, my lord, I have 9 crores bills pending. They say, sitting in my office, we assess that according to our this formula, in whatever way they apply, the damages would be 12 crore. So your 9 crore is adjusted as against that, pay us 3 crore more,
Remaining
amount. And the second case, what they do, my lord, that's, my lord, there's a very specific thing. Even if, my lord, I concede to the observations which just fell from my lord, that there is the loss has to be presumed and therefore they are entitled. But what they have done is, my lord, they have made a double recovery in the second case. Whatever security was lying, they have forfeited that also separately. And apart from that, my lord, whatever money we had earned, my lord, that has also been forfeited. So if your lordship just sees, my lord, the second file, my lord, for a moment, my lord.
That's why only the learned single judge interfered with it.
The learned single judge, my lord, the honorable single judge has quashed it completely. Suppose, my lord, they are left. My lord, they can't be allowed to retain my money,
Now,
double the
they
money.
can't stop from doing anything until and unless, what we feel that yes, opportunity is there for them to again quantify the damages and then claim. That is what
I would
can't say that now they have stopped from.
my lord, may I request your lordship to take the second file, page 123.
Yes.
Page 123, my lord, second file. Please look at the arbitrariness, my lord, the way they have proceeded.
So that's why only the learned single judges, we are not disputing that, sir. We are not going to say that whatever they have done, it is correct.
Still, my lord, I am very, very tempted, my lord.
Keeping it open to them. They can quantify and then claim the damages, that's all.
My lord, may just bear with
In
my,
accordance
my lord,
with
may
law.
just bear with my imperfection, my lord. I am just so tempted, my lord, just show one thing, my lord.
Yeah,
Please,
sure.
Please, my lord. Page 123, my lord, of the second file. Second one, my lord, the second appeal. Serial number 8, my lord.
Yes.
My lord, this is that notice, which is, there were 2 documents which were under challenge. The first was previous page. That was a notice of, that was a termination order, which has rightly been set aside on the ground that we never gave a notice also of a proposed termination. Apart from, my lord, the ingredients not being attracted. But, my lord, this document, last one, my lord, which is the last nail in the coffin, my lord, if I may say so. 123 it says.
In whose coffin? Last nail in whose coffin?
My lord, after my termination, my lord, my coffin. I am dead. After my death, my lord, they are issuing this.
But if the last nail in the coffin, then you can't be, you are not supposed to come and again come. If the coffin last nail is already there, then you are dead. For
My lord,
all
my lord, I am sure, my lord, I am safe. My lord, I don't appear as a ghost, but as a dost.
Yes.
My lord, page 123. Dear sir, this is the document. This has reference to the termination letter so-and-so,
Yes.
to your work order so-and-so. And further, due to your poor performance and since you failed to achieve targeted production, the contract was terminated. As per clause 6.3, so please look at the calculation of so-and-so dues are to be paid by you. So what is the dues that they are claiming? Liquidated damage 10%. How much is the, that's 11 crore.
Direct.
That's 11 crore. All right, Milord, that's direct, Milord. That's the maximum they could do.
That's the
Now, Milord, what they are doing?
Huh.
Please be with me, Milord. From liquidated damage 11 crore, they have already recovered penalty in past. So 92. So, Milord, now they say what remains is this security deposit in the form of cash. So that security in the form of BG, all that added together 17. So, Milord, their claim is 17. Damage is 11, reduced to 10. But they say since we are in possession of, we are in the position of possessing your money in addition to all this, so all that is also ours.
That is not,
Just look at the,
that is not correct.
and therefore, my lord, the follow-up sentence is, the above total dues of 17 crore includes cash security 4 crore, bank guarantee so-and-so are to be forfeited.
That is not
So,
correct.
my lord,
This is
my
certainly
lord, this is the kind of action which was in the contemplation of the legislature when they engrafted section 74. And my lord, then fortunately, my lord, the judicial side of our constitutional setup, my lord, did not allow that to also remain.
can't be.
Further, my lord, there was interpretation.
Can't be allowed. Yes, we are absolutely, you are correct. It can't be allowed. But certainly after quantifying the damages, they can recover the damage. Can't,
My lord, at least, my lord may observe that by resorting to adjudicated report.
judicial form without adjudication, whatever it may be,
So, my lord, otherwise, my lord, they will again do the same thing.
they'll again do, then come again.
My
They'll
lord.
interfere with this.
My lord, please.
What's the problem in that?
My lord, may at least,
For
Lord, may at
this
least-
we are here only. It
Lord-
will not come.
my lord, I have relied up, my lord, I have relied up, with respect, my lord, I have relied upon a pronouncement.
To such type of litigants who are consistently making these errors, and therefore we are here.
For us, my lord.
My lord, we are all the more obliged, my
We
lord.
will not admit this. But we are taking upon ourselves. The courts are here. Otherwise, what we will do? If they do not commit the errors,
My lord, I am wondering what the DGP would be saying.
Yes.
So, my lord, only that much of clarification, my lord, that they have to only
See
adjust.
to-
And my lord, it will be open for me to take all legal factual defenses.
We'll see. Yes. And
Otherwise, my lord, my claim for interest, my lord, is should be treated as premature, depending upon the future adjudication. That also, my lord, otherwise I'll be dubbed by, I'll be, my lord, restrained by res judicata.
And whatever observations we have made that you have approached this, filed this appeal only to counter this, this was somewhat, some way correct.
No, my lord, my lord, since 2013, they are retaining my money. Since 2013, my lord, it has been more than 12 years.
Let us see. Yes, sir.
We did not come before the Honorable Court. We only placed our demand. And we retained certain amount of money. And the balance we paid.
Without quantification, without adjudicating the loss, you can't claim. In a unilateral manner, you can't claim. That you yourself has calculated the damages and asked him, and whatever the money he was having, you have forfeited that. That can't be there.
As per the contract, we can we told.
Close for
My lord,
all.
I am sorry, my lord.
Sorry.
I intended, my lord, the first sentence I intended was, my lord, the answer to his last sentence. First sentence I intended was, my lord, that parties agree on a contractual clause. There is a limitation on that imposed by the legislature. For example, my lord, whatever damages or liquidated damages you have contemplated, it is the maximum cap, reasonable compensation. And then whatever legislature has said, my lord, there is a limitation put upon that by judicial interpretation. This case is one case, my lord, where they say that according to contract, we can do whatever.
They can't.
Legislature says you can't do, judiciary says even that much you can't do, which legislature is saying in express words, because in our.
What you are not is only content for point of point that they can't do it. So because the to make a quantification, it was that without that quantification, you can do.
Lord, I respectfully bow down, my lord. My only apprehension was, my lord, all along, that left to that extent only, without any clarification that they have to go through adjudicatory process, my lord, they will again do the same thing, my lord. There will be multiplicity of litigations, harassment.
For that we are here.
My
For that
lord,
we are
my
here.
lord, I'm sure, my lord.
That we are here.
I'm sure. I'm so grateful, my lord, for the patient hearing.
We will try to clarify.
My first opportunity to appear before my lord,
Right.
my lord. I'm so grateful. my lord.
For hearing, item 10.
Yes. Is there? Apply in a copy. Apply in a copy. In another case.
Way to move it to Belek.
Sorry.
That's all. Okay. This PIL petition was filed by the petitioner, agreed with the action of the executive officer of the municipal board, Tezpur Municipal Board, of allowing by allowing the playground of the Tezpur Academy Higher Secondary School to be used as a parking lot. Full stop. We said permission, the permission of this effect was granted by the Tezpur executive officer of the Tezpur Municipal Board on which date?
9th April 25.
Anji?
9th April 25.
No, the initial permission.
Initial permission.
Your lordship. Let us.
Is there any, you have annexed the permission?
Your lordship, we didn't get the letter, your lordship, but we had that letter number, your lordship. Your lordship, 23/5/23, your lordship.
Which is that order?
Para 5, your lordship, page 8.
No, this order nahi hai.
No, your lordship, we didn't get that. That was not provided to us. But subsequently in the affidavit, your lordship, filed by the respondent, your lordship,
Yes.
they have annexed the letter. Page 38, copy of the letter dated 25/5/23.
In view of, I would like to request you to afford necessary permission for utilization of this fund. Yes, वो क्या लिखा है? No, against the. Look at this, this PL petition is filed by the petitioner agreed by the action of the management committee, the SDMC of the Tejpur Academy Higher Secondary School, whereby they have allowed whereby
Lordship, actually,
temporary permission was granted to use the school ground of the aforesaid school as parking pursuant to a request made by the chairman of the municipal board, Tejpur, the Tejpur Municipal Board. Full stop. The said request was made on 25/5/2023, and the school has granted the permission for using the school playground as parking on 26/5/2023. This court while ordered it. (2012) 2023 has ordered that in the interim, the respondents are directed to not to act in terms of any decision that they may have been taken in terms of the letter dated 23/5/2023, meaning thereby restrained the respondents for using the school playground of the Tejpur, which school is there?
academic.
Tejpur Academy Higher Secondary School as parking. Full stop. Today, learned counsel for the state has produced a communication sent by the chairman as well as the executive officer of the Tejpur Municipal Board to the District Commissioner Sonitpur, whereby the request made by it to the Tejpur Academy Higher Secondary School for use of the playground as parking has been revoked. Full stop. The letter dated 9/4/2025 is produced and taken on record in view of the fact that the Tejpur Municipal Board has already revoked its letter seeking permission for use of playground of Tejpur School, Tejpur Academy Higher Secondary School as parking. No further order is required to be passed in this PIL petition. The same is therefore disposed.
Left over matter item 6.
Matter. My lord, this matter may come after 4 weeks, my lord.
After 4 weeks?
My lord.
Why?
My lord, there is a development, my lord, the Upen Das, there is a case, my lord. Due to this judgment, my lord, I was not given benefit. But against this judgment, my lord, Upen Das, there is a, my lord, SLP admitted, my lord, before the Supreme Court, my lord.
In the month of, at the request of learned counsel for the appellant list in the month of August
All right.
2023.